So hello again. Welcome to our June 2022 research seminar. This event, as you know by now, is run by the Linguistics and Translation and Interpreting Group at UNSW Sydney. My name is Ludmila Stern. I'm Professor of Interpreting and Seminar Convener. And I'm delighted to welcome our audience who are joining us from interstate and overseas. This is very impressive, from different time zones, just like our presenter. So as I said, this seminar is recorded. Before I start, I would like to acknowledge the traditional owners of Bidjigal and Gadigal land on which University of New South Wales, Sydney stands. I'm speaking tonight from my home on Gadigal land, and as a migrant to Australia, I'm grateful for the privilege of having built my personal and professional life on this land. And I acknowledge the traditional owners of this land, their languages and cultures, and I pay tribute to elders past, present, and emerging. And I also acknowledge and pay my respects to the Aboriginal and Torres Strait Islander people who may be joining us today. So let me now introduce our speaker and the topic of her presentation. So Dr. Lee Swigart is Director of the Programs in International Justice and Society at the International Center for Ethics, Justice, and Public Life at Brandeis University. Lee is a linguistic anthropologist who has overseen diverse programs in the sphere of international justice, including the Brandeis Institute for International Judges and the Ad Hoc Tribunals Oral History Project. Her academic work and publications have focused on the challenges of language and cultural diversity in international criminal courts and tribunals, language use in post-colonial Africa, and African immigration and refugee resettlement in the United States. She is also the co-author of The International Judge, an introduction to the men and women who decide the world's cases. Lee's latest initiative is Language, Culture, and Justice Hub, which provides a virtual space for those working at the nexus of these phenomena to discover new publications, commentators, ideas, and trends. And if you want to follow Lee's work and find out more about her publications and other activities, I'm going to post in a couple of minutes the links to her sites in chat. Lee's seminar today is entitled From Working Language to Situation Language: How the International Criminal Court Addresses Diverse Linguistic Needs. So, Lee, thank you very much for getting up so early in your part of the world to speak to us while it is evening here in Sydney, and our audience are in different time zones, as I said. So Lee will speak for about 45 minutes, which will be followed by Q&A. And you can then post your questions in chat and I will read them out. So Lee, over to you.
Thank you so much, Ludmila. I feel very honored to have been invited to talk to everybody today about research that I carried out for a number of years about language services and how language diversity is handled in one of the most important international institutions that we have in the contemporary world, love it or leave it, the International Criminal Court. Even people who are critics of it have to be impressed, and I hope you will be after this talk, about how this institution has handled the challenges of linguistic diversity. And I want to do a special shout out to my ICC colleagues that I can see are in attendance. So Ludmila, I'm going to attempt to do my screen share here. So let me do that. So as Professor Stern said, I'm a linguistic anthropologist by training, and I did my early work in West Africa. My doctoral work was about the way in which urban residents in Dakar, Senegal, use their languages, in particular, the most widely spoken language in that area, Wolof, with the official language and language of education in the state, French, and how they combine them in their everyday speaking into a kind of fluid urban code. And when I moved into the field of international justice and was working with international judges, I was always had a keen ear for linguistic issues that arise in international courts and tribunals, which by definition are very diverse institutions, not only in the constituents that they serve, but also in their own internal staffs. And when the ICC started operation and all of its early cases were on the African continent, my ears just perked up. I thought, how is this institution handling the challenges of providing language services in languages, many of which do not have written traditions, that don't have well-developed glossaries, certainly don't have trained language staff, interpreters and translators. So that was what the impetus for this project. So what were the questions that I was looking at? One of the challenges of the ICC, unlike predecessor international courts and tribunals, is that it has a global mandate. It's not site-specific like the International Criminal Tribunal for Rwanda or the former Yugoslavia or the Special Court for Sierra Leone, where the number of languages in play were predictable. There may have been many of them in some cases in Sierra Leone, and to some extent former Yugoslavia, fewer in Rwanda. But the ICC does not have that certainty. At any time, there could be a crime situation that comes onto its radar screen and ends up being investigated and then results in trials. And the ICC has to very quickly pivot in order to provide language services in those languages. And of course, there are these languages that are called languages of lesser diffusion, which I will come back to, which pose particular challenges. And then I'm also very interested in how multilingualism functions inside the ICC itself. And I should just say that between about 2017, 2019, I made many trips to the ICC. I did 60 plus interviews with people across the organs of the court, and both people who provide language services and those whose work largely depends on the work of language service providers. And I had to say that's a lot of people at the court. That really nothing can happen there without the people who are providing language services. So I can't overestimate the critical role that the language services section and other language service providers that they provide at the court. So the mandate of the ICC quickly, it's unique in the history, the very short history of international courts and tribunals in the world, in that it doesn't have an absolute jurisdiction over crimes, that it works in complementarity with national jurisdictions to investigate and prosecute international crimes. Those are genocide, crimes against humanity, and war crimes, and now the crime of aggression, which I should have added in there. But only when national jurisdictions are unable or unwilling to do so. So it doesn't rush in. There has to be some sort of negotiation to see which jurisdiction is going to actually prosecute the crimes under question. So this relationship called complementarity, which is completely unique in this field. And very importantly, victims have the right to participate in proceedings at the ICC. And that means that their particular perspectives are brought forward during trials. But also, of course, this means that there's a whole different level of attention to language services that needs to happen in order that they can have meaningful participation in the proceedings. So let's just look at the language, the official and working languages. There's no surprises. The official languages are like they are at the United Nations and other international institutions. They're the big players. In principle, the judgments of the court and other documents are translated into all these official languages. The reality is that they not always are. There's not the capacity to do it. And the working languages of the court are English and French. And again, that's pretty standard, but I will come back to that because there is an interesting interaction between the working languages that I think poses some real problems for the court. It's the rights of the accused are very interesting to look at in the Rome Statute of the International Criminal Court. The Rome Statute is the establishing convention for the court. It's called the Rome Statute because it was negotiated in Rome. Article 67, rights of the accused. I have underlined two of the parts of this article because the ICC has set a higher standard for language service provision by the language, the text of this article. So you can see that the accused has the right to both understand the charges against him, and I'm going to say him because all the accused people to date have been men, and to follow the proceedings in a language which the accused fully understands and speaks. So in the UN Convention on Covenant on Civil and Political Rights, and in the statutes of other international criminal tribunals, and in the European Court of Human Rights, the formulation is generally in a language which the accused person understands, tout court. So when you add on fully understands and speaks, all of us who work in languages know that the bar is set higher for what the level of comprehension is about that language. And that comes up again and again at the court. So the language services section is the unit of the court embedded inside the registry, which is the administrative organ of the court that handles the bulk of the language service provision. And you can see here that it services a huge array of different units and sections within the registry, including providing support for defense, which does not have its own organ. The main organs of the court are the presidency or the chambers, presidency, I guess, the office of the prosecutor, and the registry. So LSS, the language services section, is providing services to all of these. It makes for an enormous workload. The Office of the Prosecutor has its own language unit, and I'll come back to that because there is some collaboration between the registry and the Office of the Prosecutor at a certain point when they're developing language services, and then they split. And this is essentially to avoid issues of cross-contamination or transfer of information that's confidential. So here are the situation languages that were play in 2018. This was a graphic that was created by the language services section, which they shared with me. So I don't have one that's for 2022, but you can see, actually, I've been in touch with people at the LSS, and most of these are still in play. But situation languages are those that are relevant to a crime situation. And it usually is a number of local languages that witness is going to testify in, that victims and others of affected communities are going to receive information in. some of these languages there will be simultaneous interpretation in for trials, depending on what the accused is going to follow his own trial in. And you can see how many there were in 2018. There were 32 African languages that were being handled over 9 different geographic situations. And this included 3 distinct dialects of Arabic and 2 dialects of Swahili. And at that time, the Georgia, the first non-African situation had come onto the scene, and there were 3 languages relevant to that: Georgian, Ossetian, and Russian. And I should just say up front, French is a working language of the court, but French is also a situation language in many of the cases on the African continent where French is an official language of the country, and that would be Mali, Cote d'Ivoire, Democratic Republic of the Congo, and the Central African Republic. So French has played sort of a dual role in these early situations and early cases. So, but let's just look at what's happening now. There are currently 17 situations under investigations. And you can see that the work of the court has expanded outward. It's not confined to the African continent anymore and Georgia, but there is the Bangladesh, Myanmar case, Palestine, the Philippines, Venezuela, and of course, Ukraine. So what we have now is there's new languages, new language families, new writing systems that are relevant to the work of the court right now. And there are 3 current preliminary examinations. A preliminary examination is a phase of engagement by the court where it has been informed of the possibility or of alleged crimes that have taken place. And the preliminary examination phase looks at largely documentary evidence, talks to NGOs and others to sort of see what the basis is, what the basis of evidence is for there being crimes that seem likely to have taken place, or that hit a certain threshold of gravity, so that the court would then undertake an official investigation. So it comes before the investigation phase, and not every preliminary examination results in an official investigation. And indeed, if you look at this map, and there are 3, those are the blue countries: Guinea, Nigeria, 2 more African countries with lots of languages, and Venezuela, a second Venezuelan case. But the gray countries, there were 6 other preliminary examinations in those grayed out countries that were just dismissed, and there will not be movement into an official investigation phase. So what are the principal language activities of the court, of the language services section? There are many. Transcription is an activity that happens particularly in the Office of the Prosecutor, which entails the transcription of witness statements and interviews by investigators in the OTP, as it's called. And of course, these activities apply not only to the working languages, but also to situation languages. And I am going to go over the first 4 of these very briefly to give you a sense of how LSS is handling this, this need to provide services in a wide array of languages. So perhaps the activity that's most unfamiliar to the layperson is the work of terminologists. But it really, this terminology work serves as a central foundation for the more recognized activities of translation and interpretation. Let me just note that anything that's in italics here, and there'll be a lot of these in my slides, these are quotes from interviewees. So I just want to illustrate some of the points I'm making by what my interviewees brought forward from my conversations with them. So it's really, really important that there is the use of consistent terminology across the court. And I mean, this just even gets into human resources. What is the equivalent of a post when the recruitment announcement goes out in English and in French, so that there's an understanding that these are the same, that these are the same positions. That itself is a really big challenge. But there's also needs to be a database of terms that are really fundamental to these foundational documents of the court, the Rome Statute, the rules of procedure and evidence, the elements of crimes, and so on, so that the translators, interpreters can be using the same terms. And then, of course, imagine some of the languages that the court is handling, that there are not available convenient terms for a lot of the specialized language that the court is using in reference to crimes, to evidence. How do you express prosecutor in a particular language? What about rape? What about guilt? What about innocence? It goes on, and yet there has to be, if a language is going to be used to communicate all of the work of the court, and particularly when it comes to be used in a trial, in the context of a trial, there has to be consistent terminology. So the court is very, very careful. And when I say the court, I mean language services section is very careful about this work. And just general in respecting its mandate to have language rights of the accused. The distances that they go to make sure that they are respecting those rights is quite phenomenal. I was actually pretty blown away by what they do and how serious they are about it. An example is that when a language is going to be used in a trial, expert panels of linguists, of elder speakers of a language community, and so on, will come together to develop terminology that in a situation language that does not have the necessary lexical items. And the LSS is so careful about this, that they did this in the early days with Acholi, which is a language of northern Uganda, in preparation for a trial that then took a really long time to start, because there was an arrest warrant out for a number of people in this situation. And finally, somebody, Dominic Ongwen, was taken into custody and was tried. And between the time that they developed terminology and then they started the Ongwen trial, they realized that some of the terminology wasn't working. It wasn't conveying what they needed. And they reconvened a panel to sort of review the terminology they were doing. So that's the level of care that LSS takes in providing language services in languages that have not been well developed in this field. So here is just a page from a courtroom phraseology that was created, a bulletin that was created in 2012 that LSS shared with me. And this phraseology, this bulletin, consists of dozens of predictable phrases that will be used throughout the phases of ICC proceedings, so that there is consistency in the way that it's expressed in the messaging and so on. So you can see it's in English, French, Lingala, Congolese variety of Swahili, Sango, which is from the Central African Republic, Standard Swahili, and Arabic. And the idea is that these are really predictable phrases that will be used. And so interpreters can have recourse to this phraseology in order to be expressing this in a consistent manner. So this particular page is from the section on the commencement of the trial. And you can see these predictable phrases: in order to convict the accused, the court must be satisfied of his guilt beyond unreasonable doubt, and so on. So this was a really big project for LSS, and I'm unsure whether there have been new languages added to this phraseology. So there are also terms, linguistic terms, legal terms that are quite specific to the ICC. And that sort of raises different kinds of challenges. So just to cite Ludmilla Stern. She has called these preemptively minted meaning-based neologisms when she's writing about certain work in international criminal tribunals. And an example here is, I already mentioned the notion of complementarity, which of course the word complementarity means something in our everyday parlance, but in the context of the Rome Statute and the ICC, it means something very particular about a sort of a collaborative approach to jurisdictional matters between domestic and international courts. And so we have it in English and the French equivalent, complémentarité. But then we get into some kind of strange ones. So the word in English for charges, criminal charges, is not in French what it normally would be, which is chef d'accusation, but it's charge, les charges, disclosure, not communication des pièces, but divulgation. And then you have this common law term indictment, which in French would, in other contexts, be acte d'accusation, has been completely rejected. So the English and the French both have a new term, which is document containing the charges. You will never hear anyone at the ICC talk about an indictment. It's a document containing the charges. And then you have the very strange sounding term in French, document contenant les charges. So these are terms that anyone working in languages and across the court generally has to get used to using these neologisms. So translation is the second activity that I'll talk about that LSS does. And this is a huge undertaking, of course. And most of you, I think, in this audience work in languages so that you know that translation is, we're talking about written texts that are rendered from the original language into another language. But LSS, the Language Services Section, is the authorized producer of these documents across the court. They do administrative documents from the presidency, from the Public Information Office, Human Resources, IT, the legal office, and all of these. But always judicial documents take precedent. And that means, not only full judgments, but also judicial decisions, interlocutory appeals, and so on. And just to give you a sense of the task that translators are asked to do, let's take a judgment, a judgment of the standard judgment of the ICC, might be 400 to 700 pages long. It can take 6 to 8 months to have to produce an authorized translation with multiple phases of revision and proofreading. So this is a really big undertaking. One of the challenges for translators, and let me just back up really quickly and say that most of the documents that are created, produced within the court are in English. And I will come to this later, this dominance of English. So that means that the translation is very generally going from English into French. And there are many more translators working from English into French than the other way around for that reason. But one of the challenges of translators at the court in the LSS is that they have to build bridges to jurisprudence from other international courts and tribunals like the Yugoslav Tribunal, the Rwandan Tribunal, the Special Court for Sierra Leone. And of course, given that there are these special terms that are used at the ICC, this can be quite a challenge. So a translator, on top of the hard job they have of doing this very complex translation of a judgment, that they need to connect ICC judgments to others that might be cited within it. For example, those from the Yugoslav and Rwandan tribunals. So that means that they need to make it possible for a legal researcher, in the future, for example, to understand that although the term indictment is used in maybe something that is cited, that is the same thing as a document containing the charges at the ICC. So the legal concepts are the same, but the terminology is different. So this is sort of an added challenge on top of the translator's job. Of course, translators are important partners in the creating clear judgments. And many translators will say that when they have difficulty translating something in a judgment, it's often because the thinking is unclear. and they will go back to the person or the team that has drafted a judgment. They're not always very happy to hear that something is unclear, but that is generally the case. So then there has to be sort of a back and forth about how the original text could be changed in order to be made more clear and to be able to be translated. And then finally, translation is not just for working languages, it's also for situation language texts. Sometimes it depends on whether someone's going to be reading them in the situation language. But the LSS has been so innovative in how it manages to respect the linguistic rights of the accused, that it has sort of had to really create new ways of making it possible for people to access the charges against them, the document containing the charges. And let me give you an example. In a case involving Darfur, there's a situation language that was called into play called Zagawa. It's a very small speaker population, probably fewer than 500,000 people. It does not have a written tradition. And yet there was an accused person who had indicated that that was the language that he was going to be able to follow his own proceedings in. So what did the court do? How can you have a document containing the charges, which was very, very long, more than 100 pages, if I remember correctly. And how could the person who only could really speak Zagawa, was unable to read, and if he had been able to read, there's nothing written in Zagawa anyway, how is he able to actually access charges against him? So what the court did was to come up with a way of doing a site translation that was digitally marked by page and by section of the document containing the charges, so that when the counsel for the accused person wanted to indicate a particular charge, that person, the counsel, could sort of find it digitally and play the site translation for the accused person so that he understood what crime he was accused of and what was being talked about. So it's quite astonishing what the court innovated in order to really fulfill its mandate in I think the most respectful way. So of course, you don't always have, it's not just translation, there's also issues of transliteration when you are dealing with languages that have a different writing system. And this came up sort of when the Georgian situation came before the court. Here we have tweets from the International Criminal Court, from the Central Communications in English and in Georgian. And the challenge there was that there are several competing transliteration systems used for Georgian, and the court needed to make sure that it was using the same one all the time, in particular, so that proper nouns, names would be recognized as the same ones, place names and names of people. So that was a whole sort of a procedure they had to go through to decide which system they were going to do and make sure it was consistent. Field interpretation. So what that means is anything that's taking a place outside of the courtroom, whether it's right there in The Hague in the detention center or in the victims and witnesses section, or it's in a situation country. Most of the field interpretation essentially uses a consecutive mode, and this is an activity that is often carried out by freelancers who, of course, are vetted and for security and for other criteria. When the ICC realizes that a language will be relevant to a situation and to a proceeding or an investigation, then they come together with the Office of the Prosecutor, their language services unit, and they work together to source and recruit and train for these interpreters. And they have a specially designed accreditation process. But when they sort of get this accredited group, and they can start with a large group, and by the time they do security, health, whatever, do they have the capacity to do this? Do they have the language skills that are really necessary? They could start with 100 people, let's say, and come down to like 15 or something. But then the Office of the Prosecutor and LSS will split their roster, as I mentioned before, for purposes of avoiding sort of the leaking of information between the prosecution and the defense, and they will then a field interpreter will be assigned to one or the other and not move over unless it's really strictly necessary. So one of the problems with the field interpretation is, when is the ideal time to start this rather long process of finding field interpreters? You're going to need field interpreters immediately when official investigation is open, so that investigators can get out into the field and start doing witness interviews and so on. So during the preliminary examination phase, the LSS is sort of watching carefully to see, when they really think they might need to start recruiting and training and vetting or whatever the field interpreters. Because if you do it too soon, there may not be an official investigation. That's really a waste of resources and time. On the other hand, you don't want to be left with nothing prepared at all when an official investigation is confirmed and then the activities begin. So there's a little dance they do during the preliminary examination phase. And I just said there were 6 of them that were just recently dismissed. So you can see that this is quite possible. It can happen. But the LSS will start looking at what kind of resources are out there for a language that might be relevant. Are there glossaries? Are there grammars? Are there trained interpreters? Are there academics who are working on particular languages? Are there NGOs that work in, we're using these languages? And that way they kind of have a sense of the sort of landscape of a particular language, so that they're poised to sort of jump into action when they need to be. The other thing is that during a preliminary examination phase, LSS doesn't really want to put out a recruitment for a language expert in a particular language, because it's signaling to the world that there's actually an investigation going on, and that can be very counterproductive. Here I just have some quotes from people that I interviewed who are language service providers. And it really underscores the absolute necessity of situation languages to the work of the court, and sort of uncertainty that they are dealing with. And also, it's really interesting to think about, who is going to come forward and be vetted and be trained as a field interpreter, because of course it would be nice to have someone who had some linguistic background, or legal background, but you can't depend on that. It's also really helpful sometimes to have different kinds of interpreters. For example, women who might be able to be more effectively be in a situation where there is where they are doing a witness interview about sexual violence. So there have to be thoughts about who the actual people are who are carrying out these things. But sometimes they don't have any choice. There's a limited number, as one LSS staff person said, and I think he's on this talk. He said these are not off the shelf people. We can't just pull in a field interpreter off the shelf. That we have to create them for the purposes of our work. So courtroom interpretation. I know that there's some people here are probably practitioners, and you don't need to be informed about the complexity of this kind of interpreting. But often when I speak to audiences of legal people, they're really not aware of how particular the practice of courtroom interpretation is, and what it really demands of the person who is undertaking this. And again, I'm happy to cite Ludmilla here that lays out some of these some of the real challenges of this kind of work. And it has been very interesting for me to interview courtroom interpreters and hear about what this really is like for them. So now we come to the issue of courtroom interpretation and languages of lesser diffusion. And I use this term early on, and let me come back to this because this is a kind of a specialized term. So languages of lesser diffusion are those that have few speakers in a given location. They're generally non-standardized or largely oral in some cases, and for which there are very few translators or interpreters who are accredited. So now the reason I say that they have a few speakers in a given location, Swahili is an LLD in The Hague, but Swahili in East Africa has 200 million speakers. So it is not a language of lesser diffusion there. However, it is in The Hague when a Swahili interpreter is needed. On the other hand, a language like Zagawa from Darfur is a language of lesser diffusion, even inside Sudan. So it's really sort of a contextual term. The ICC, and I won't go into the details, but they have come up with a system for training simultaneous interpreters in languages of lesser diffusion for languages that are going to be key to the trial. So they don't go to this, they don't go through this whole procedure for a language that's not going to be used on a regular basis in the context of a trial. So they have an in-house specialized training that they do at a very accelerated pace. There might be some simultaneous interpreters in this audience, and I'm sure 6 to 8 months sounds like a very short time period in order to produce a simultaneous interpreter. In most of the situation languages that have been used in trials, so in the courtroom in the ICC, they also work bidirectionally, which is they don't in French and English, for example, but they do in situation languages. So you will have someone doing Swahili to English, English to Swahili, or sometimes Swahili to English and French and English to Swahili. And as far as I know, to date, there have been interpreters trained in Acholi from northern Uganda, Lingala, the Democratic Republic of Congo, Sango, which is Central African Republic, Swahili, both in the Congo and in Kenya, 2 different dialects, and Zagawa. But there may have, since in the last couple of years, maybe there have been new ones that have done. So perhaps somebody who's in the audience from the ICC, from LSS, might be able to tell us whether there are any more simultaneous interpretation languages that have been added to this group. One of the things that I was really struck by when in doing my interviews and in my observation at the court is sort of the stance of those who are providing language services at the court. You know, they already language services professionals occupy a unique and really critical role in that their work really underpins the work of all the rest of the court. And all the LSS staff, of course, take an oath to be neutral and accurate, you know, in their activities, and to, you know, to safeguard confidentiality of information and texts that they work with. But another professional stance that I really observed by language experts at the ICC has never been articulated explicitly, and that's like the absolute humility with which they play a supporting role to the rest of the court. And they are keenly aware of how critical their role is, and they're also very aware of how they're really invisible. I've called this in one of my publications an ethics of invisibility. So they are aware that in a way, for them to be invisible means that they're doing their work well, but it also can run up against certain times the sort of lack of comprehension on the part of the people for whom they're providing services. Their lack of comprehension of what this work really entails and how important it is. So yeah, bravo to all the interpreters out there and all the language service providers. So as an anthropologist, of course, I'm interested in cultural issues. And as I have been doing my work around language, of course, there are corollary cultural issues that are sort of, running alongside linguistic issues all the time. They really go, of course, hand in hand. And I've written a whole article about cultural issues at the ICC, so I don't need to talk about them too much. I think Ludmilla might have put a link into a page I have at the Language, Culture, and Justice Hub, where you can access all of my preprint versions of all of my publications if you're interested in more. But let me just talk about a couple of cultural issues that are really salient. One is that there are certain topics that come out in testimony, whether in witness interviews by the Office of the Prosecutor or later during courtroom proceedings. There are certain issues that are very difficult for some people to talk about directly, and sexual violence is an obvious one. And that when somebody is asked to detail what they have actually been subjected to, this is an important part of demonstrating that the crime has actually, the elements of the crime have been satisfied, so that the crime really took place. And yet, a woman may be asked to provide details that are just painful to articulate, particularly in a public setting. And so this is something that the court really has to work with somebody and try to sensitize them to the need to do this. But it's not even just the person giving testimony. Sometimes it's hard for the interpreters who are from situation countries also to do that. So they need to be really aware of the need to be as direct as possible and to really sort of bring forward in a direct and sometimes blunt manner the nature of what is being conveyed by the person speaking. There is a huge outreach section at the court that LSS also services, but they also have people who speak some of the languages inside their office, but they have to really think in culturally specific ways about how they're going to get the message across from the court, what the court does, what it can do for a victim population, what will happen if a person who is accused is convicted, what does that mean in terms of after effects of what by the court. And they have to think really strategically, well, how are they best going to get the message out culturally? Are they going to use print? Are they going to use radio? Should they have town hall meetings? Should they have gender specific gatherings if there has been widespread sexual violence so that women are not there with men? If they have a meeting for women, do they need to provide childcare? All of these things are cultural strategies that they have to have in order to communicate the messages that they need to communicate. Another issue that's come up, cultural issue that came up in my interviews, was that around mental health and trauma and the courts having psychological interventions. They do have psychosocial workers and people and people who are providing testimony are evaluated for their capacity to actually provide testimony, particularly in the courtroom. So if someone has been brought, let's say, from Uganda to The Hague to provide testimony, are they going to be able to actually sort of get through this process? So there is someone who's doing a psychosocial evaluation. But there's a lot of stigma in a lot of the situation countries around the idea of having a psychologist or a psychiatrist. And a common reaction, according to an interviewee from a situation country, is that they say, I'm not mad, I'm not crazy, I don't need that. So there's a certain reluctance to have any kind of psychological intervention. At the same time, this same interviewee said that she believed that the psychological evaluations are so derived from Western diagnostic models that in some ways they don't fit very well with some of the people who are being evaluated from situation countries. And in particular, she believed that there was an over attribution of trauma to people who she said, are very resilient and have very hard lives. And so that there just may be a disconnect between the models that are being used and the people who are being evaluated. So one of the things that comes up for the court is how to communicate really, really critical functions. And one of the ones that comes up all the time is this idea of reparations. So if an accused person who is convicted of having overseen or allowed or carried out crimes in a particular community, then that community can be the recipient of reparations by the court. The problem is that it's sometimes in certain languages very difficult to communicate the notion of reparations without it automatically conveying that these are it's monetary compensation. And there are different kinds of reparations that can come out post-conviction after a trial. There could be health facilities that are built. There could be paying for education for children who have lost years of education due to conflict. There may also be some monetary compensation, but in some languages, it's very hard. There may not be a lexical item that conveys reparations without conveying the idea of automatically of monetary compensation. So this is something that the court is trying to sort of finesse all the time. And finally, I mean, something that I was really struck by in terms of the institutional culture of the ICC is that it just tends to value legal expertise and other kinds of related expertise over linguistic expertise. And that can be seen in the way that that posts are filled. It can be seen in the way that the need for someone with linguistic knowledge can be pretty consistently undervalued. Yeah, it's just I'm just thinking of some of the posts that have been, for example, there was somebody who became the head of a field office in a French-speaking African country who didn't speak French. Someone who worked in the employee welfare office who didn't speak French. Someone who works in the victims and witnesses section, helping with the arrival and sort of the making people who've arrived to provide testimony comfortable, and not having anyone in that office who would speak the language of that person. So there's just this idea that, oh, if you have, you're a psych person, you would be good, but they don't have the language expertise in a way and able to actually do their work. But that's just a cultural, I think, an institutional cultural issue at the court. Oh, why is this not? Okay. So I just have a few slides left, and I want to just get into something that is really interested me, and that is what I call the case of English versus French. And so I'm really interested in the relationship of the working languages to one another inside the institution. And I like to show this sign or this logo from the court because it's literally the only situation where I've ever found where the French language is on top of the English language in anything having to do with the court. And I think it's just because it's alphabetically ordered. But I see there as being three different types of impacts of the domination of English over French as a working language at the court: symbolic, practical, and conceptual. And it's very obvious to people who would prefer to use, who are French language dominant, or who would prefer to use French as their, that they used French in their education, or they come from a French-speaking country. There's a level of frustration that they feel because of the unequal status of French and English as working languages. In terms of the symbolic weight of speaking both working languages, I think in the early years of the court, the top leadership spoke both languages and were able to communicate in both languages. The president, the prosecutor, the registrars, people in the head of defense, people in key positions. And I think they feel that really sent a message about the global character of the court. And of course, French is a working language, but it's also been a very important situation language in the early years of the court. So it was very important for many reasons to be able to speak French. And that meant that the top leadership of the court could talk to heads of states in situation countries, and even with stakeholders who are able to speak French. So having French has been very important. And I have a picture here of a former prosecutor, chief prosecutor of the ICC, Fatou Bensouda from Gambia, which is an African country with English as an official language. It was a former British colony. And Prosecutor Bensouda used French regularly. When there was an opening of a trial, she would, it had to do with a French-speaking African country, she would do her opening remarks in French. She could go to a reparation ceremony in Mali, and she could deliver her remarks in French. Earlier presidents in the UN, they would sometimes speak French, and then they would switch to English. So there was this idea that this is a multilingual, multicultural global court. Contemporary current leadership they're Anglophone. I don't think they speak any French. And I don't even think they've made a pro forma statement about that they will become conversant in French, which used to sort of be at least, the statement that you would hear. So there has just been a turning away from the idea that this is even a necessity, or it's even desirable. So what are some of the practical challenges that go along with the domination of English over French? I have published about this, so I'll just mention really quickly some of the things. So, having people within the court who can't even at least read both languages means there's a huge, huge amount of work and a huge dedication of resources to the translation between English and French. And I should note in particular that the Office of the Prosecutor is very, very English language dominant. I mean, there are people heading investigation teams in French-speaking countries who are unable to read a French language statement by a witness, which means that they have to wait for a translation even to read a witness statement. And somebody in an interview in there said, I mean, the OTP can become paralyzed by waiting for a simple translation of something from French into English, whereas, learning to read at least a language to peruse something or to figure out if it's relevant or important is not a hard ask, but it's not happening, even though the ICC actually offers French language instruction for people who want to do it. Of course, there's a burden that's placed on those whose working language is French. They constantly have to use English in meetings. If there's one person who doesn't speak French, there's always the accommodation of the English speakers. They have to do the extra time and effort to be writing a memo or an email in English, when French would be the language that they could much more easily and naturally do it. It's clear that there's advantages of being a native speaker of English in particular in recruitment to ICC positions. They have candidates who are native speakers of English, have the facility and the sort of comfort level of being able to express themselves in the context of a recruitment interview. And it's other people who have it as a second, third, fourth, whatever language do not have that advantage. And something that I found really, really interesting is this idea that at some point in the detention center of the ICC in The Hague, there was a sort of a message going around among accused persons saying, even if you don't speak English and you would like to be able to speak directly to your counsel in French, be sure and have someone who speaks English, because they can then speak directly to the judges. So, and the judges are increasingly English speaking. Most of the panels of judges are functioning in English. There are very few that function in French. So in other words, accused persons might actually be sacrificing their own ease of communication with the person who is handling their defense, so that that person can have an ease of communication with the people who will be passing judgment in the case. So conceptual considerations. As I said, native English speakers, especially those who are maybe monolingual, they often seem unaware of the advantages that are conferred to them by the fact that they can function effortlessly in the ICC's normal linguistic environment. But I also want to raise this idea that they may also be blind to the way that language shapes the very way that they think and view the world. So what is the court losing by having people in particular who are monolingual English speakers? So I love this quote from Anna Wierzbicka, Imprisoned in English. And there have been a number of people who are multilingual at the court who have noted that there tends to be this sort of conflation in a way of monolingualism in English plus a common law background that leads people to have a particularly narrow and inflexible view of the world and of the work that they are doing, and even the legal concepts that may mean something a little bit different at the ICC, but they are unable to actually get beyond what that term and notion might be in their home jurisdiction, because they don't have that sort of intellectual flexibility that comes from having been working in another language. So as someone says here, an interviewee, it's a very multilingual, multicultural court, but English dominates. And there's also supposed to be a hybrid legal system, but common law is also dominant. So there's kind of a it's less of a global institution because of this sort of language plus legal culture kind of sort of adding on this sort of conflation. So I'm almost finished here, but I just want to bring up something something I've been thinking about. I have a paper that's about English language hegemony at the ICC that's about to come out online someplace, supposedly. I haven't heard about it, but I really explored this idea of what are the impacts on the ICC of English language hegemony. And one of the ideas that I speculatively sort of explore in this paper is what it might mean for a multilingual institution like the ICC to have a monolingual ideology. So the term language ideology is something that linguistic anthropologists use, and it's really just a term that means the everyday or lay person's assumptions about how language works. And this can mean lots of things. I mean, you know, we hear someone speak, they have a particular pronunciation accent, and there's all kinds of assumptions that we are making about that person based on that. That's a certain kind of language ideology. The idea of a monolingual ideology is interesting, and it's a very powerful ideology found very often in the world of language policy and education. And this monolingual ideology understands multilingualism to be the composite of distinct monolingualisms. And it assumes that multilinguals move from one bounded system to another, ideally speaking each as if it were their only language. In other words, language use is really being judged by what could be called a monoglot standard. And I think those of us from Australia and from the US, we see that every day in our societies, that there is a monolingual ideology. There's a mistrust of people who speak other languages. There's a dismissal of people who don't speak it in a certain way. And yet we come from countries that are very multicultural and have large immigrant populations, and they are sort of suffering from this monolingual ideology. And I just want to do a shout out to Language on the Move, the wonderful research platform based at Macquarie University that has had a lot of interesting commentaries that gets at this idea of monolingual ideology in one way or another in the Australian space. So in addition to this idea of a monolingual ideology, I just want to call attention to a notion that is very very common in language studies, sociolinguistic studies, and linguistic anthropology, for a couple of decades. And this is this idea of what they call translanguaging. Translanguaging just refers to the phenomenon of using resources from different languages together with very little regard for what are considered the boundaries of named or identified languages. And this idea of translanguaging captures exactly what I was looking at in the 1980s when I did my doctoral research, which is that people were using French and Wolof together in an unconscious and fluid way, not knowing what they were using from which language. If you asked somebody to repeat an utterance, they would use a different combination of the two languages from what they had used before. There was just a high level of unconsciousness, and people felt that they had this broad repertoire that they could constantly be calling on across these two or more languages. So why I'm bringing this up is I think it's an interesting sort of conundrum, perhaps, for people who work in language services and translation, and in particular interpretation, because the industry of interpretation is really based on this notion that there are distinct languages that can occupy a particular technological channel at a given time. And yet a lot of people, that is not their normal way of speaking. As you can see in this, this quote from Francis Rock. So what are the implications of this idea of a monolingual ideology for the ICC? I think it has implications for how the language skills and needs of accused persons who are used to using a wide repertoire of languages can be assessed. The court and LSS is being asked often by chambers or the office of the prosecutor, what does this accused person really need in terms of language services in order to follow the proceedings against him? What does he need? Does he really need to have Sango? Or can he really follow it in French? Do an evaluation. So maybe this person's evaluated and it's like, well, neither his French or Sango seem like seem really good. Well, there may be a reason for that, that this is a person, a translanguaging individual who's used to having recourse to his full repertoire. And so in the context of a language competence assessment, this is an artificial test for a way that he does not normally speak. And I think this translanguaging is a phenomenon that is really typical of the post-colonial world, in the sense that you have post-colonial countries that kept a colonial language as an official language. So you have this functional variation about how people use languages, that they may speak a whole range of languages, but they may only be educated and read and write in an official language. And I just point out that maybe there's progress in the court sort of thinking about this, that last year there was an accused from the Central African Republican case. They noted that he had functional differentiation in his language skills, that he was orally strongest in Sango, but can only access written materials in French. So there might have been sort of an argument for him having sort of a mixed sort of bag of language services in order for him to really follow his own proceedings, his own trial. Okay, so just some conclusions, and these are conclusions sort of about my research, my entire research project with the court. You know, what I've observed is that over the years of the operation of the ICC, that there seems to be sort of a narrowing of language skills among its staff, at the same time that its geographic presence and the need to accommodate new languages is widening. So I think that is perhaps a problem. And I mean, there's nothing sacred about a duopoly of English and French, right? I mean, so English is dominant, but if French had equal status, that in the scheme of things, that's nothing as two languages in, you know, a whole universe of languages. But what I think is perhaps more troubling is that there is, I think, a need for a certain intellectual flexibility that is, some would argue, enhanced by multilingualism, that's really important for the people who are doing the kind of work that's being carried out at the ICC, and that is perhaps lessening. There have been people in the world of international law who have suggested that maybe a workaround for this would be that English would be sort of the standard working language that everybody needs for communication within an institution, but they should have another language. It doesn't have to be French. I know the French wouldn't probably like that conclusion, but they need to be multilingual in order to have that kind of awareness of what it is to have different perspectives on the world, and to even understand what it means to work with multilingual colleagues, that you yourself should have to speak a language other than English. So as one of the courtroom interpreters said in an interview, if you have several languages, you have several ways of expressing the world, and so to see the world as well. And an institution like this one, we need more of that, I think. So let me these are the references cited from Professor Stern and also from Francis Rock. And I just wanted to point out the websites of the Language, Culture, and Justice Hub, which I hope you will visit. And if you want to become a member, let me know. Just to look at the spotlights, the monthly spotlights on language, culture, and justice. They're all in an archive and so on. And also, if anyone would like to read any of what I've published about the ICC and earlier about other African languages in international criminal justice, there are preprint versions of my papers that are on my own member page on the Language, Culture, and Justice Hub. So thank you very much.
Thank you so much, Lee, for such a comprehensive and very interesting and challenging presentation.
And I'm just seeing the time. I didn't realize I went on so long, so I apologize for that.
That's fine. Look, we have about 15 minutes for questions. So if anybody would like to comment, you know, maybe colleagues from the ICC, I can see a few. I can even see Alex Tomic there on the slopes of Swiss Alps. So if somebody would like to comment and or ask questions, please go ahead in chat. Or actually, I think we are all fitting in here on one page. So if you want to raise your hand and unmute yourself, that is fine too. While we are waiting for comments and questions. Oh, okay, Diederik, please. Yeah. Hello.
Hello. I'll switch on my camera just so you can see me
Great.
as well.
Hi, Diederik.
Hi.
Hello. Yeah, it's so nice to see you and to hear you, Ludmila and Lee. Thank you so much for this fantastic presentation. I myself, as you know, but for everybody else, still work at the Language Services section of the registry at the ICC. And I recognize a lot, practically everything what you've been saying as part of our daily environment. So thank you very much for that. Of course, the language list that you've shown, and the number of situation languages at the court has grown and keeps on growing. So that will need some updating. And in that respect, our challenges keep on multiplying with regards to facilitating language services, whether it's interpretation or translation into languages that hitherto hadn't been used on a global platform such as an international criminal court. So, I mean, the challenges are very well described. Thank you very much again for that. And if you want an updated list of situation languages, of course, we'd be very happy to provide that to you. Maybe one little addition, maybe interesting to mention as well, that with regards to court interpretation, as you've mentioned, situation languages have been used, situation languages that are not like on the general market, so to speak, of professional court interpretation. So these interpreters are indeed trained to the extent possible by the language services section at the registry of the International Criminal Court. But there's, and you've mentioned the languages Acholi, Swahili, Lingala, Sango. Indeed, trainings have taken part. When we have, in some of these cases, it's the only booth in the world that are providing simultaneous interpretation in these languages. We are about to start another training similar to this in Four language for the Sudan situation and trials related to Darfur. Apart from the simultaneous, in some instances we just have one or two witnesses or a couple of witnesses that speak a situation languages and does not justify in terms of resources and budget for us to train to do a 6 months training for interpreters. So in those situations, we've also do a much shorter training to provide consecutive interpretation in the courtroom. So this has been the case, for example, in the ongoing trial in the Al Hassan case related to the situation in Mali. The situation languages that are used and also spoken by some of the witnesses in court are Tamashek and Songhai, for example. Now, for these languages, we did not do a full 6 months training, but because of some need, we did do and we have an ongoing support for, let's say, the field interpreters to provide consecutive interpretation at hearings in this case. And this is another challenge that we are facing, more and more, actually, also in situations as more languages keep on being added to some of the situations. These challenges are also become our daily bread and butter to try to service. So thank you very much, and I'll leave it to others also maybe to comment on your great presentation. Thank you.
Thank you, Diederik. And thank you also, Eliza. I can see your comment on Tamashek and Songhai as two Malian languages in the courtroom to complement what Diederik just said. Any other comments or questions? Please feel free to raise your hand or write in chat. While we're waiting, I might make a comment, Lee, or rather it's a question. During my observations of court proceedings, I was wondering whether the fact that the judges who preside at the ICC are often not native speakers of either English or French. They come from the Philippines or Hungary or the Czech Republic or Italy. And in a way that is not unique to the ICC, but also to the former ICTY. Do you find this concerning, that the judges who make important decisions, who assess the witness testimony, who communicate among themselves, may not have a native command of the two working languages?
Well, yeah, that's an interesting question. I mean, there's no workaround for that. And in fact, it is really interesting. Even judges who've come in where French has been their stronger language have found that they have had to learn English better, because that's how they're going to be functioning. Even if they're in a French language panel, the rest of their communication across the court is going to be in English. So is it, I mean, yes, I mean, I suppose it is. But what's interesting, Ludmilla, is when I did a number of interviews with judges, and found across the board that they had very little to say about interpretation. I think in some ways they're so hooked into their headsets, and that they are just taking on faith that what they're getting is accurate, which I think in most cases it is. And if there are inaccuracies, LSS goes back and they correct them. But they seem to they just didn't have very many observations about multilingualism and what was happening. They were choosing the language that they were hearing the testimony in, and that was sort of good enough for them. I think that in my work with international judges, and in the earlier publication I did on international judges from many different courts, I found that there are sort of different ways that international judges approach their work. And some judges want to learn everything about the place that they are, the crime situation, so that they can be better informed. And other people say, all I'm going to judge on is what I hear in the courtroom, and I'm just going to take it, and that's what I'm going to make my decisions about. So I think there's a particular judicial character that I found in a way not as curious about these issues as the people who are in other functions of the court.
This is absolutely consistent with my experience of interviewing the ICC judges, some of whom said, well, this is the first time I'm actually thinking, or I was made to think about interpretation, which is quite ironic. I'm about to read a question from Jack Keating, which is this: given the importance of having translation consistency at the ICC, it must be difficult to achieve textual equivalence among all the situation languages at the ICC, and maybe even between the two working languages, given the dominance and preference of English, which you have highlighted. When translating, do you think that the presumption that textual equivalence can always be achieved is an important legal fiction for the ICC to operate under?
Thanks for that question. I'm an anthropologist and I'm not a practitioner. So in some ways, I think that might be a question that somebody who is actually working in this field could answer. But let me just say one thing that I saw and that people in my interviews commented on, which is that that there's just a high level of misunderstanding about equivalence in general. And I didn't describe the scene in an ICC courtroom, which is highly technologized. Everybody is behind a monitor, and the monitor is used for visual evidence. There's pictures and there's videos, and there's the scans of documents that are being referred to. But a lot of people on the defense and prosecution teams, and maybe even the judges, are also watching the real-time transcription, because the court has to produce transcripts in both English and French, for every hearing, no matter what language is being used on the floor. That is probably the only situation at the court where French and English have a equal role, because these transcripts have to be produced from the hearings. And I didn't even get into the fact that the official trial records are from these transcripts, which is an irregular use of interpretation to actually create a formal record of a hearing. But there's no other way around it. There can't be full translations of the millions of hours of hearings. But what some people have noted is that there's a tendency for people to be watching the real-time transcription in the language that they read. And if somebody knows a little French, that's usually what it is, as opposed to a little English. Not understanding this idea of interpretation, that they will be pointing out that they will be suggesting there are inaccuracies in the interpretation because they don't think they are seeing what should be, what they would consider to be the textual equivalent. So in other words, they say, wait a minute, they just said this in English. Shouldn't it be this in French? And so they mark it. And then LSS might have to come back and say, no, this is sort of the nature of interpretation, that there's not going to be this. So so there is a problem in that these official written records of hearings come out of interpretation, which is not translation. So there's always going to be a lot of difference between them because of the nature of interpretation.
Thank you, Lee. I wanted to return to the notion of translanguages, translanguaging that you mentioned. And perhaps my example is going to be inaccurate in terms of the concept. But what I observed, among other things, during the interpretation into some of the situation languages, Sango, for example, is that the beginning of the interpretation into Sango, when it was a question by one of the parties, would begin with the French, est-ce que, followed by the Sango question. And when I conducted post-observation interview with Sango interpreters, they explained to me that sometimes they adjust their target language expression depending on who the witness is. And if it is, for example, an urban person, maybe army personnel, who is likely to be educated and versed in French, they would rely on some French loans. Whereas if the witness comes from the rural area without any knowledge of French, but only Sango, then they would do a paraphrase or, use a neologism and so forth. But I always wonder, and this question really comes from also my question about what happens in domestic courts, in national courts. How much do the defendants or witnesses understand what goes on? And I feel that it's very well to coin equivalents or paraphrase or provide an explanation. But I wonder whether the discourse as a whole allows the speakers of situation languages in particular to follow the proceedings, to be able to involve with their case, or whether they entirely rely on the defense to explain what goes on to them. Sorry, I started with translanguages and I ended up with something else. I can see that Aida raised her hand. So yeah, perhaps you answer firstly. And
well, let me just say that well, I would have loved to have the chance to talk with an accused person in the detention center about how they were experiencing this, but there was no chance that that was ever going to happen. So in a way, that whole and an accused persons very, very rarely actually testify. So we really very rarely hear from them at all. But let me just say, I mean, if a Sango interpreter is using that kind of flexibility and understanding who the audience is, that's exactly in line what somebody who comes from a society that's doing translanguaging would do. I mean, that is my experience with Urban Wolof, and maybe Ida will comment. She's an Urban Wolof speaker. That, I mean, adding eska, I mean, there's obviously a way to formulate a question in Wolof, but eska would just be just a really common way to signal that this is a question. And also, they may not, I mean, Eska in Urban Wolof is not really considered French anymore. I mean, you just have to understand that when you come in and you speak French and you hear French lexical items, you're thinking, oh my God, they use French, but that's not necessarily the level of awareness that somebody for whom this is so natural and so everyday. You know, they are not seeing those boundaries necessarily. But it is true that, you know, I have seen situations in Senegal where the people in the urban area say, we need to protect the language. You know, we're going to, you know, have this word for economy that we're going to use in Wolof, and they use this word, and the people in the like village are like, what's that word? It's because it's a Neil. What's that word? And they said, are you trying to say economy? Is that what you're trying to say? Because that's already entered into their lexicon. So I think that there can be maybe an over complication. It's normal to have loan words. Personally, I think that it might work to use loan words in some of these situations for terminology instead of creating explanatory phrases, much less new words.
Yeah.
So that's
Thank you. Thank you. Thank you, Lee. So Aida, over to you, please.
Hello, everyone. I'm sorry I don't have a camera, so you won't be able to see my face. But to just answer what Lee has just said, in Wolof, indeed, the French words or even the Arabic words that are in our vocabulary are not French or Arabic anymore. They are part of Wolof, and more or less everybody understands them. However, I have received one day a text in, well, it was a translation of mathematics in Wolof. And it was perfectly understandable in Wolof because we used Wolof words. Well, the person who translated that used Wolof words, and I was joking. I answered saying, so now I need a double translation. I need somebody to explain to me the mathematics and somebody to tell me what the Wolof words are in French. But in all the languages is that we just adapt something. But coming to your question, Ludmila, about the accused understanding what's going on. We have to take it in all the official languages in this world where there are tribunals. A French person needs a lawyer to get to a tribunal. Otherwise, we wouldn't need any lawyers anywhere. The law is in itself a language that everybody needs translation in. French to French, we don't understand all the concepts when we are in front of the judge. There are some things that go way over our heads, and then we need a lawyer to explain to us exactly what is going on. And that is in the same language that we all know at the same level. We just don't know the law. And in situation languages, it is the same. The interpreter can interpret perfectly what's going on, but it is for the lawyer to explain the content of what is being said most of the time. When it is just witness testifying on something happening, okay, there's no problem. The interpreter interprets and the witness understands. But when it is the accused who is to understand the legal concepts, whatever the translation we give that person, if his lawyer does not explain, he will not understand, because it is the legal concepts that need explanation, not the day-to-day language. So it's our interpreters are put in somehow a very difficult situation. But with all the trainings we've had training with terminology, and we have developed several bulletins that explain in French and in English what our concepts are. And we are translating them during our trainings with the field interpreters or with the para-professional interpreters. we explain to them those concepts and they translate them in their language. So the need of the lawyer will always be there, and the interpreter cannot replace the lawyer. So that's the end of my comment.
You know, Ida, that kind of makes me think of a whole other issue in law, which is the plain language movement. That yes, you need sort of an interpreter just to understand the language, and there is sort of a move to just simplify that. Now, I know that there's particular terms in international criminal law, you know, that maybe can't be gotten around, but I do think that there is a stance on the part of lawyers that they have a niche. Their niche, they protect their niche by having a certain kind of complexity of language.
But of course, you can then argue that any profession, you know, medical, for example, scientific, you need terminology. You need to be able to speak to your peers and not only to lay people. And I also want to thank you, Aida, for your comments and explanation. I know that we went over time, so Lee, let me thank you again for an excellent and very informative and thought-provoking presentation, very both scholarly and practical. And please, everybody, join me in thanking Lee by, you know, you can use, you know, any icons, any symbols there. So thank you very much, Lee, again. And thank you, our audience.
Thanks to everyone for attending. I know it's not a terribly convenient time for you either.
Oh, well, but I'm very pleased that we made it happen. And thank you, Lee, for such an early start.
You're very welcome. It's a pleasure.
Yeah, all the best to everyone, and see you next time. Bye-bye.
Bye.
Bye-bye.